come across some good concepts here to help everyone really to get funded, or really not so much get funded, not just get funded, but secure whatever exit strategy we're looking for. And not necessarily an exit strategy too. Sometimes the concepts that we're going to talk about create also in trying to just put together a strategic partnership, or putting together like a joint research group with another company or institution. At the core of everything that I just mentioned, there's going to be a reason, some sort of situation where someone's going to come to you and they're going to say, hey, why, convince me that your products are protected. Convince me that your business is protected. Why should we do business with you? Why should I invest in you? Clicker is
not clicking.
Just a quick little bit about myself. I'm a licensed patent attorney. So I've taken the California bar and the U.S. patent bar. And prior to law school, I actually got conducted my studies at UC San Diego. So I went to law school here in Irvine at UCI. But prior to UCI, I was at UC San Diego, where I was studying neuroscience, and then prior to after my graduate studies, I actually worked in immunology at an oncolytic virus company down in San Diego as well. A little bit about the firm, Wilson Sonsini. We're a global law firm. We've been around for a long time. We're one of many of these larger law firms. But what we specialize in is specifically innovative tech companies, high tech, biotech. We've really kind of geared our practice towards serving these types of companies. We're the law firm that took Apple public back in the 80s, took Google public in the 2000s. Now we're the guys that do Roblox or Genentech, Fubu or Fubu TV, anywhere from life science to high tech. And a large reason why we're successful in doing that is because we've created these teams, these specialized teams that are really largely a lot of ex-scientists, a lot of people such as yourselves, a lot of ex-entrepreneurs. That have done the pitch competitions, that have been in that seat, asking these people for money. So we kind of, take every part of our practice and gear it towards that angle. I'm specifically in this group, the patents group. So we work specifically with the patent office to get our clients their IP protection. And we're going to talk about exactly, this is the easy part about what I do, getting the patents. The hard part is actually the more interesting part, I should say, is going to be actually talking to the investors, talking to your future partners and saying, hey, why is this patent portfolio actually worth a damn? So before we talk about that, patents are just one form of intellectual property. There's several other forms of intellectual property, including copyrights, trademarks, trade secrets. Now, they all serve their purpose, and they're all valuable for different people. For innovative companies where your value, your business is changing the paradigm, it's bringing some sort of innovation to the table, whether it's a device, whether it's a game perhaps, or a new way of doing things, a new method of doing things, a new composition. Patents are going to be your number one form of intellectual property protection. Think about these examples. If once upon a time, back way when, somebody came up with Tylenol, right? Before there was a patent on Tylenol. If you want, the person that made it, they want to go sell Tylenol, right? If someone had a trademark to the name Tylenol, but no patent on it, you can just go change the name, right? Trademark some other name. But if that person had a patent on the chemical composition of what we call Tylenol, then suddenly you can't go sell that anymore. You need to completely change your business, right? It's not just changing a name. You might have a copyright on the box, what color the bottle is. You can just change that, but what you can't change is the actual composition. So what does a patent do? Why does a patent, create what I just, that situation we just talked about? It's because what a patent is exactly, it's the right to exclude. That's what a patent is. Whatever is in the patent, your invention of the patent, once it's issued, once your patent's issued for a temporary amount of time, 20 years from the earliest filing date, you have the exclusive right to exclude everyone else from doing what's in what's your invention. We're going to talk about what exactly the invention is, because the patent has different components. Only the claims are the invention. We'll get to the claim. But that's an important concept that we're going to keep coming back to. Whatever is subject to claims is what I can exclude others from doing. So what exactly is a patent? This is on the left side is what is a cover. On the right is one of the figures. Patents have usually a lot of figures. And then there's going to be a lot of text in the patent. But at the very end of all the text, whether it's 50 pages, 20 pages, 150 pages, we get to numbered sentences. At the end of these numbered sentences are the claims. These claims define your invention. This defines what other people cannot do. This is what they're excluded from doing. Sometimes you have a method. Sometimes your claim is as simple as, there's supposed to be a picture there with text, but it looks just like this, except it's it can be a composition. And again, what do these claims mean? You cannot import, make, use, offer for sale in the United States whatever's defined by those claims. Okay, again, they need to be issued claims. We'll talk about the difference between issued and pending applications. But once it's issued, you're given this, you're essentially given this temporary monopoly over what's in that application. So people ask, people ask me all the time, well, why are we giving out this temporary monopoly? I thought in the United States we don't really trust the monopolies, but actually you're given, this temporary monopoly is an award. It's an award because what you put in your patent application is going to be published. All the patents published, right? So the idea is, hey, you're putting a publication out there. The world's going to profit. The world's going to, benefit from your scientific advancement. We'll give you this temporary monopoly. People will innovate on top of you, and society moves on. Are there any, I think we have time, since it's a small enough group too. Are there any questions so far about, kind of the basics? Just so far, just the basics of, we'll get into the business, but just the basics of, a patent and the mechanics of a patent. Any questions from you guys? No. Okay. Okay. So now that we've kind of discussed, the basics of a patent, let's talk about how it actually helps out the business, your businesses. First step of appreciating patents is making sure that you don't get sued, right? Now, this aspect is the amount of depth that you need to know about this all depends on the amount of financing you're looking for. For example, if I'm looking for, $500K from friends and family, or $20K from friends and family, who what have you, they're not gonna really, they're not expecting some $50,000, in-depth landscape analysis. Me saying, hey, I've looked at everyone else's patents. I know exactly how, our product doesn't infringe these patents. But if you're getting, for example, $1 million pre-seed, or for example, actually even $500,000 angel investment, you can expect the question is that, do you know of the biggest competitors in the field? You should be ready to, you don't necessarily need to say, hey, I've looked at all of Genentech's patents. We're all 1,000 of them. We're good. They're not expecting that, but you could say, hey, I've looked at, X and Y major products. I've identified their IP. And at least those were good, right? If you're taking like $1 million, maybe $2 million, you can expect that VC that's giving you the money is paying a sophisticated attorney like me somewhere between $20,000 to $50,000 to say, hey, take a look at their IP, or take a look at their product, make sure that if I invest, a couple million in these guys, they're not going to get sued 5 years from now before they even commercialize, right? Or not before upon commercialization, they really, they get screwed. So some people tell me, hey, I've already gotten a patent on my thing, or we just licensed a patent from UCI. What do you mean we might get sued by someone else? So a great way of kind of thinking about that is this three-legged chair example. This is kind of this example is going to be the basis for really the entire patent system. You come around and file a patent application on a chair comprising 3 legs, right? You get your patent issued. Now you have a patent issued that says a chair comprising 3 legs. So we go back to this thing. Yours says a chair comprising 3 legs. Right? Now I come around after you, and I file an application on a chair comprising 4 legs. The patent office says, oh, this is different, but really close to 3 legs. Why should we give you a patent? What's so special about this? And I say, oh, well, I ran some data, some experiments, and if you add the 4th leg, you actually get 20% more stability, 30% more comfort, and based on these trial and error experiments, there's empirical data to show, hey, the 4th leg is actually unexpectedly better. You would think it would be better, but you wouldn't actually think. I actually did the data. I reduced the practice to these experiments, and I actually figured out we're getting this much improvement, X amount of improvement by this 4th leg. It's extraordinary that we're getting this much improvement. The examiner's like, okay, I'm convinced. I'll give you a patent on a chair comprising 4 legs. Now I come around and immediately I get my patent. I'm super excited. I start selling chairs with 4 legs. You can still send me a cease and desist letter and say, hey, your 4-legged chair is still infringing my 3-legged chair patent, because my 4-legged chair still has 3 legs as defined by their patent. So just because you have some IP, just because we've created our own IP, doesn't necessarily mean we're out of the woods. And this is the type of analysis, depending on the check size that we're looking for, this is the type of analysis that an investor might be looking. Now, this 3-legged chairs and 4-legged chairs, it's a pretty primal example, but the way it played out, this is kind of how it's playing out for the CRISPR conundrum right now. This is the first patent that was by the UC and Austrian teams. It's kind of complicated. We don't have to dig into it. It's mainly this is CRISPR in a patent claim. A couple months later, MIT and the Broad came. Very similar claim. They just specifically say eukaryotic cell. This is a 3-legged chair. This is a 4-legged chair, the 4th leg being a eukaryotic cell. Once someone, this was subject to one of my other talks, but once people start commercializing CRISPR, we're still far from commercialization. Once you start commercializing it, depending on who you have a license to, you might have to go talk to the other person. And of course, as we all, you've kind of seen patent infringement in the news, Apple v. Samsung, what have you, that's a consumer facing. Even in the face of these biotechs, Illumina, EGI, this is the world of gene sequencing, a patent infringement case can still land you in a lot of hot water. Any questions on the kind of the FTO aspect of the patent strategy? Yeah, question.
Just a curiosity question for Chris. Because there's a fine line between common sense versus life science, biology. From outside perspective, people will say, oh, that's not obvious. But from inside perspective, they'll say, that's so obvious, it's common sense. What I heard about this battle between the 2 patents is that equilibrium cell, from an insider perspective, that's common sense. Nothing unique or novel about this new patents. But from the outside perspective, I think this is novel enough as a new technology, new innovation. How do we, because we are already in this industry, we cannot see this from the outside perspective. Right? So moving recommendation, when we are looking at something, it's hard to define, is this common sense versus not common sense? Like, how do we know this is
Yeah,
gonna be
great
right?
question. So there's a lot of different things to unpack here. First of all, there's a difference between what happens in the courts and litigation, and then the process of getting a patent. They're similar, not exactly the same. If you go back to my three-legged chair example, what did I say? How did I get my four-legged chair claim? What did I have to supply? Data.
Evidence.
Evidence. If there wasn't, if the data is not there, if there isn't some sort of significant I'm gonna have a lot of trouble getting that claim in the first place. In the tail for CRISPR, so let's just actually, before we get to CRISPR, when something's close like that, the only way to get it across is data. You have to build a case for why, hey, empirically there's a significant change here. Or if it's not a significant change, it's at least a degree to which, just by, it's one of skill in the art, you would think there's some improvement, maybe marginal improvement, but the data shows is actually unexpectedly better than even what a PhD in the field would think.
Who will be that PhD then?
It could be you, it's the inventor, it could be anyone.
I mean, who will be the judge, make this decision, that is something unique for,
So when you're getting your patent, it's the patent examiner. So it's someone that has probably some sort of technical background, not a strong technical background, but someone with a technical background who's not a lawyer, and is judging your case. So if you're in court, it's gonna be a judge with no technical background whatsoever. So for the CRISPR case, that was actually, they weren't in federal court yet. So far, there's just been an interference proceeding, and that's been done at the USPTO. So technically, those judges should have some sort of technical background. In those cases, they actually, MIT brought on an expert witness that successfully argued, that argued and was convincing enough to those judges that in this case, the translation from a prokaryote to a eukaryote wasn't trivial. It wasn't like some of these translational medicines that we've seen that you do it in mice, it's roughly the same dosage as done in a human, just kind of multiply by a factor. In this case, the fact that it worked in prokaryotes had less of an indication, less of a bearing that it was going to work successfully in eukaryotic cells. And that was done with an expert witness in administrative law judge proceedings. That same battle is most likely going to be done in the federal courts in a couple of years.
How's the doctrine of equivalence related to this?
The doctrine of equivalence?
Yeah, would they appear to have one?
Well, so the doctrine of equivalence comes into play only when you're asserting a claim against a product, right? And the person that owns the product says, "Oh, my product doesn't do all of your claim." Then the person that owns the patent says, "Okay, you don't do everything, but you do something that has to be equal to what something I do in my claim." In practice, doctrine of equivalence is you rarely win on doctrine of equivalence. It's a tough stuff. To an investor, I never want to say, "Oh, I don't infringe someone's patent because I think I blocked my competitor because of doctrine of equivalence." They're gonna say, "Oh, no, they don't really think you're blocking your competitor." That's not a convincing story for why you're blocking your competitor. So the second aspect of your patent strategy is making sure you don't get ripped off. Making sure you can convince your investor that we're not going to get ripped off for a very long time, because as we all know, where most of us are selling products that have to go through a regulatory pathway. These patents are only valid for 20 years, right? How are we, and we're not going to be making revenue for 10 years. The timelines are a little messed up here, but with effective use of that 3 to 4-legged chair example, you can actually create a viable strategy that's going to protect your life science product for a very long time. this is generally how it plays out, how the strategy plays out. Your first filing is only just your first filing. This could have been developed in-house, it could have been developed in conjunction, it could have been some of your graduate work at a university. It could have been, or it could have been work you've maybe done at a prior company or a prior, in a prior life that, you were able to acquire from that company, license from that company, right? But this first family is the three-legged chair, so to speak. Then when you see the second family, it's being filed at a very specific moment. It's being filed 18 months after, usually 18 months after day zero, year zero. Because at 18 months, the first family is going to publish. So if we file before the publication, that first families can't be used against the second family. Okay? And then but when we get to family 3, now the first family is going to be usable against the third family. But the idea is by the time we get to family 3, we have data to show, hey, these improvements make the product that I'm describing 3 years later better than the product that I had 3 years ago. In practice, it's not that difficult. In 3 years, we hope to have innovated. But in examples here, if you're in the business of therapeutics, right? Perhaps your first family is the drug, the API, whatever chemical you synthesize at the university. You license it out. Second family, you discover, if you didn't already know the best indication to use this drug for, now you know the best indication. Or if you had an indication in mind, perhaps now you develop, a diagnostic, some sort of diagnostic. Hey, people that are low for some sort of biomarker, it's better if I use this drug. That becomes, that's your hook. That's your fourth leg in family number 2. Oh, we didn't know at the time of the three-legged chair, at the time of the API, synthesizing the API, we knew it'd be good for muscular dystrophy, but we didn't know it'd be especially good for people that had muscular dystrophy that test, below X threshold for whatever biomarker, right? When you get to family number 3, maybe at this point you're filing your IND, you're into phase 1, you have data to show specific dosages are more tolerable than others. That's information, that's data-backed information we didn't know at family 1 and 2. Now you have family 3. Next step, perhaps there's a crystal form or a salt form of your drug that has better solubility, right? You didn't know that data. You didn't know that families 1, 2, 3, and 4, or 1, 2, and 3. Suddenly you have family 4, and you keep building that out, and and then let's play this out to investors, right? Depending on where you are in the cycle, you're probably going to be far, you might be far from devising this plan that we just talked about, but you can at least say, hey, I'm talking to my lawyers, they've looked at the technology, we have a plan. As long as the money keeps rolling in and we keep developing this, we have a plan to make sure that our products are still going to be protected for the next 40 years. Come invest in us now. I know our regulatory pathway is still another 5 to 10 years, but look at this, we're good to go.
So is that the strategy? Is it a continuation in part?
Absolutely not.
That's different, right?
Yeah.
Okay.
So in this case, when you file the subsequent, patent families, the original patent family is extended to the new family because it's like different patents here we're talking about, right?
No. So each of those arrows ends at 20 years. You could use this as a continuation in part. Family 2 could be a continuation in part, but if you do a continuation in part, you're not getting any of the benefits and only giving up the cons.
Okay.
Because when you do a continuation in part, you're implying that there's new matter. The new matter is still going to be graded against the old matter. So if you have new matter, you might as well just start a new family.
Okay.
And if you do a continuation application, not a continuation in part, just a continuation application, it's not going to extend the arrow. A continuation application is just another application in family 1.
Mm-hmm.
Okay, so the only way to expanding one family, that's like operate the kind of green up on you can extend the life of that particular family.
That's right. For certain regulatory processes, no more than 5 years, but part of that is the delay time can be used to extend the life of usually just one family. An example, the clearest example is with the Orange Book. So for therapeutics, you have to list which ones of your patents covers a FDA approved drug. There's a similar book for biologics. For medical devices, it's a different path for medical devices. But for the Orange Book, for example, you can select one of your Orange Book patents and use a portion of your phase two delay time into extending that. That you have to think of there's a lot of thought that goes into that, because perhaps you don't want to necessarily go family one because family one's going to end sooner, but maybe family four could be your extended release. So not everyone gets the extended release. So family four doesn't cover everything, but it still has the long. You have to put some economic time into thinking which one do I want to extend.
Does this mean that the first pattern family and second pattern family is dominant over the third pattern family?
What do you mean by dominant?
They mean that, for example, let's say, let's make it up, other company patent the third pattern, but just like the 3 and 4, but you dominant over, they still need to kind of licensing. But this one is like company own everything.
Think about this example.
Yeah.
It's all this.
Okay.
So if let's say we have families 1, 2, 3, 4, and somewhere in between your competitor came and filed before your family 4, they came up with your 4 before you did,
Yeah.
and they filed on it before you did, they will get the 4-legged chair. But if they start selling 4-legged chairs, then you still have families one. They still need to either license families one. Well, we need to do it in that. We need to make sure that their product still infringes the exact claims of family 1 and 2. But if following this example, they're still going to be subject to those patents.
Okay.
Does that make sense?
It's just like, so if we come out first with the third family because we own the previous 2, so they're not an issue for us.
That's not an issue for you.
Yeah.
Exactly. That's exactly correct. And that's why I think a lot of people I come across, it's happening less and less, but a lot of people are so adverse to necessarily like licensing from a university. Like they're so keen on removing themselves from the university and then developing their technology. Where I appreciate why you're doing that. You want to save yourself on downstream royalties, but what's going to be, if that university technology can be the first step into this, then the royalty, by the time you start selling products, that university one is going to be closest to expiration, and you're going to have families 2 and 3 that are company owned at that point. So it's better, you're more suited to you have more benefit in taking that licensing university technology, being able to go to an investor and say, hey, I have a plan to make this, and it's a absolute zero chance that anyone else can come in and take family 1 from under me at this point. No one else can license it because I already got it. And I have a plan to create this kind of structure that's going to protect us for the next 30 years. Come invest in us.
But if you are licensed that from the university, they can potentially license that to another entity as well, right?
Well, yes, but let me caveat what I said. You need to get an exclusive license.
Yeah, exclusive.
So, how is all this possible? How is all that made possible? Those relationships I was talking about. It's all just having a sound understanding of the U.S. patent laws. As long as you have a new concept, a new structure, a new step in your method, and then you have the data to empirically say, hey, this new structure imparts some sort of benefit. then we can get that four-legged chair, or we can get CRISPR in a eukaryotic cell. Right, and just understanding those laws, and then, putting that with, I think I have these specific deadlines. Understanding those laws and understanding these key dates allows you to make those really long, up to 20 or 40 different patent families. I think you might have seen in the news recently, people talking about how Humira, the drug Humira, that the AbbVie gamed the patent system, and kind of they reaped like $114 billion. They made $114 billion off Humira because it's been covered by patent for like 40, 50 years. One of their later patents, their Family 56, like got challenged like maybe 5-6 years ago by Amgen, and that patent actually it's withstood its ground. It's maintained its validity. And it's been, another 6 years of only AbbVie can sell brand name Humira, no generics. And there's all these models that show, hey, if you're in the therapeutics business, your most profitable days are actually going to be the most terminal end of your patent term, because there's more people in the world, there's more patients, there's more patients afflicted by, yeah. So what Humira is, what that gaming essentially was that strategy. So if you use that strategy for a drug that affects the whole world, like that big of a market, you might make some headlines. But the fact of the matter is, most of these drugs that these startups are developing, aren't that large of a market. And for an investor to be assured that, hey, this I'm going to get my ROI here on this company, because they're going to have to do a lot of R&D, they're going to have to do a lot of manufacturing, and they're not going to be able to sell product or make revenue for another 10 years. Like, what exactly am I doing here? They need to see a strategy like what we just talked about. So keeping these dates in mind, this is a little bit more granular play out of those three chairs, of those three arrows we were looking at earlier. But these are the general kind of, and it's adding the costs. But at 18 months, you see the other 10K, that's going to be that's the filing of family number 2.
What's that 12 months mark for? I think
The 12 months mark is going to be the conversion of the provisional application. So day 0 is going to be provisional filing. So that was year 0 in the so day 1 right there is going to be year 0 right there. And then the filing of second patent family, as seen on the screen, is 18 months right over here.
okay. And you only have up to 12 months to convert a provisional patent to.
You do. You can abandon your provisional, refile the provisional, but then you're moving your date. Right? If someone came and filed between your first provisional filing and your original conversion date, and then you didn't convert and you refiled your provisional, now suddenly the second guy is now the first guy and you're the second guy, right?
Mm.
Now you could, is this a little pointed?
No.
Okay. So you could file multiple provisional applications. So when I talk to someone, I say, hey, let's file on this. They say we might as well get. They say, oh, I'm not quite ready yet. Like, hey, if you have some novel concepts, file on it anyways, because we want to get it before you're the guy we don't know about yet. And B, we can always update your provisional for the next year. And they say, oh, okay, great. And then they usually don't give me updates till like, a couple of weeks before, a year later, a couple weeks before the 1-year anniversary. Now, it's better than nothing, but I don't like that. And I actually encourage them, as soon as you come up with any new concept, we should just file again immediately. We just copy and paste everything we already filed and just add the new concepts and just refile it. The hard cost for a provisional is less than $1,000. It shouldn't deter you from updating, because what we can do, and that's, let's say we're not ready by the 12-month anniversary of the first one, we could not refile, we don't lose all of our time.
Update it.
Yeah.
When you update, do you get another 12 months to work on it?
Yeah.
Okay.
But only, that concept only works if the update has now added a new feature. We can't just refile the same thing over, if you file the same thing, technically the second one, if it was filed while the first one was still alive, the second one is an invalid patent. But as long as we keep adding a new patentable concept, you're allowed to keep filing on the updates.
There's no limits on it.
There's no limits, but trust me, it's hard to think of that many good ideas.
Well, I mean. It's
Because chances
yeah.
are you put a lot of the updates that you're thinking about in the first one.
Right, that's kind of like the patent strategy, kind of, because, yeah.
Yeah.
Okay.
So the 30-month date that we're seeing there, it's 30 months from day 0, 18 months from your conversion date. That's the date where you have to select which foreign countries you want to pursue patent protection in. It can become a very expensive date for a startup because you have to pay an initial filing fee. And for a lot of countries, you have to pay for translations. So that's why it's 0 to 100K. If you want to just do US, Europe, and China, which covers a little over 70% of the world's therapeutics market, that's going to cost you around 30K, like somewhere between 25 and 30K. And then just beyond that is how we get to 100.
So you said Europe, US, and China,
Yeah.
or Asia, does that including like Japan and Korean?
No.
Just specific country, but you can use that as a whole. Like the patent covers, like you cover EU, the whole European Union.
So great question. For with a European patent, it can. They've done us a favor. So it's one process to get the patent judged, get it examined. Once you get it granted, you pick which countries you want to validate it in. It's going to be another big payday because you have to translate it in every single country, and it can be expensive. But you know, you want to do your market research to see what countries would, you know, are most, you know, you want to protect them. Of course, you want to hit the Western one. You know, you don't have the Western ones, but
I see. So that does not guarantee that all the European Union countries. Like
oh no, they're once you get it allowed by the European Patent Office, it's just a matter of rubber stamp. You gotta pay the other company a rubber stamp.
just each one you have.
Yeah, they can't deny it.
Oh, I see. Just automatic approval, but it just fees associated every
Yes.
time. I see.
Fees, exactly. The initial translation fee, that's why the day you pick which countries is big, because you have to do an initial translation fee, and then every year after that, you have to pay like a maintenance fee for each country you selected. Very rare for startups looking to be looking for VC funds. It's very rare that you get to a stage where you're picking which European countries you're validating it. Or if you are at that stage, it's probably for one of your earliest families, and you can get away just going, you know, UK, France, Spain, and Germany, and you know, that's it. This you know, this is kind of a probably bigger issue for like the Pfizers of the world. Any other questions here on this kind of schematic?
It's just technically, do we get a copy of the presentation afterwards?
Yeah. Okay. Yeah. One thing to note is Taiwan and Argentina. We don't get till the 30 months. That decision needs to be made at 12 months. Very rarely comes up. Some of our hardware companies, this comes up for Taiwan. For some of my agricultural technology companies, Argentina comes up. But for you guys to know when you're working with your patent attorneys, if you're interested in those, there's a couple other countries, but the only ones that ever come up are Taiwan and Argentina. That decision needs to be made at the provisional conversion date, not your nationalization date.
So at 12 months for the conversion of the provisional to non-provisional, do you have any recommendation that at what kind of criteria we need to do that conversion? What kind of criteria we need to verify the new family?
Yeah, absolutely. So you need to make sure that by the 12-month date, you've identified novel structures, if it's a device or a composition, or novel steps, a different method step, if you're doing like a service. Or if it's, if it's a service of using it, both, right? Or both of those. You need to make sure you've identified at least one, hopefully more. And then either you have the data reduced to practice and in the application that you would use to advocate for why your novel piece is good. Why that, like the two questions that a patent examiner always asks is, okay, what's new about this? Okay, well, what's special? Like, why do I care? Like, why should anyone care that you added this new piece? And that's where the data comes in. So that data doesn't necessarily need to be in the application as filed, but at the very least, you need to put a prophetic example. Say, we are going to do this. This is the experiment we're going to run. This is what we expect it's going to say. And then, because it's not going to get examined until 30 months, 30 months. You can speed it up, but if you leave it alone, it's not going to get examined until after that 30-month date anyways. Then you can bring in the data after the fact. Now, that was for the 12-month date. For 18-month, you just need to ask yourself, what novel structures have we come up with in the last 6 months that work, or what did we forget to put in what we filed 6 months ago? Again, it's same inquiry though. What novel structures? We can bring in the data later, especially for the 18-month one. Maybe you don't even know what experiments you're going to run yet. You just have to say, oh, these are some novel structures. Just put down the novel structures before 12-month guy publishes, and then figure out what we're going to do with it.
Okay.
Great question. So I mentioned, the business goals, securing financing and exit strategies. Every single large financing or IPO, any sort of diligence, it's the same type of meeting where I get in front of the lawyers of the underwriters or the VC, and they're expecting me to run through the two questions that we just went over today. Why is this a good business opportunity in that we're gonna get patent protection by the time we're ready to commercialize? Usually if it's a device company or if it's a research tool where there is no FDA, their product just needs so much more development that it's still like 5 years down the line for commercialization anyways. If it's a therapeutics company, they have their regulatory pathway that they're gonna have to deal with. So we need to put out some sort of map. So I always have some sort of visual timeline that says, this is our expected commercialization date. These are where our initial families are expiring. And this is how our new families are going to extend our coverage. That's half of it. The other half is, depending on how large the check size is, this is the search strategy. I usually have a slide that says, this is exactly what we input into our fancy system to search. I give that strategy to the investors' lawyers, who are sophisticated lawyers like me. They're going to look at the strategy and they're going to say, sometimes they're like, oh, maybe you should have looked at this instead, or maybe you should, and then I give them a reason for why we did it. Usually that reason is, oh, because we wanted to expand on these other areas that I think we can all agree are more important, and the budget is the budget. I mean, we didn't want this to be 100. It wouldn't make sense to do 100K search here. You're only paying us, 3 million. Those are kind of the two pieces, right? Having that search strategy, and then having, again, as I mentioned, the kind of that timeline of how we're not going to get ripped off. All of that goes to tell the investor or the acquirer, hey, this looks like this is going to be it's not a safe opportunity, but I feel a little bit more assured for the next 5 years, 10 years, 15 years. But let's start doing business with these guys. All right, I wanted to leave some time for questions. As Emily mentioned, these slides will be circulated, but yeah, that kind of rounds out, really what I kind of had prepared. What I'll add is every single thing that I do in my day-to-day, every work product I generate, every meeting I have, falls into one of these two buckets of 1 and 2. Going to the ultimate goal of 3. Even when I'm just, the reason I acquire the patents my work product of, what do I do when I have all these 40 patents, made for a client? Yeah, I have an Excel sheet that just has all the numbers, but I always have a PowerPoint that has a map over, here are my clients' main products that they're going to be offering. These are the products that they're telling investors they're going to be offering. Here are the patents that cover those products. Here's our time exclusivity timeline. And then here are the searches I've done on these products for various competitors, and this is why we don't, this is why none of these are a problem.
And that's part of your, like, when you prepare for the client, that's part of what you will help them to walk through, even to identify some of the potential competitors. They probably
right.
haven't really thought about it.
That's right. So, we'll ask for, if you don't know about your competitors, then, we'll ask for, we'll kind of understand your technology, and we do a keyword-based search that's agnostic to competitors. Usually our clients, especially at, more like later series, the investors will say, hey, we've already invested in these 4 other guys that are kind of doing similar stuff. Why are you getting better than them? So usually you tell us those 4 other guys, and we go look at their IP, and we put together a PowerPoint for why we answer these 2 questions. Why is our IP better? How come we're going to be able to exclude others for longer than these competitors? And hey, we don't run into any of their IP. They're actually going to run into our IP once we get it issued.
Well, I'm glad that you kind of mentioned this. This is kind of very interesting, kind of like, situation. Sometimes the VC will take on your kind of like presentation, kind of learn from you. But now, without like the true intent to actually invest rather than learn, how to avoid those like pitfalls?
I mean, that's part of we always ask that you never send anything on IP via email, and we usually try to just be involved in that conversation, because this is what we do every day. We've had countless of these meetings with countless VCs of talking about someone's patent portfolio, and I'm talking about meetings where here are 50 different patent families that our client has filed, covering all 4 of their products. Let's go through each product one by one, and we can give you the strategy for each product. To companies where we haven't even filed anything yet. This is what we're planning on filing. This is, we've looked at 2 competitors, and so far, we haven't even come up with our final design yet. But as we're coming up with our final design, talk to the scientists, they think that we can still do this without falling into these patents. It just depends on what the check size is and where your science is.
I see.
Yeah.
And early on, like a presentation, you mentioned that your company have successfully secure all kinds of fundings. Does that mean like your company is involved with those meetings, or you actually help them to explore and finding and meeting with VCs?
Yeah. So both. One thing that Wilson Sonsini offers for all of our clients, and so some even just kind of friends of our friends of the firm, is we host a life science innovative investors forum in November, and we take kind of 1 to 2 page kind of packets from all our clients, and we send that to our network of VCs, all the ones that you saw earlier. And if there's any kind of traction there, we'll fly you up, and we'll fly up to the Bay Area and kind of play matchmaker for a meeting there. That's just one event we have. We have several events like that, and a lot of times it comes down to just the individuals that you're working with. Having worked with a lot of the VCs in your field in the past.
Yeah, great presentation. And I have a follow-up question for the FTO invitation.
Sure.
So obviously, this is very specialized activity. Will most of the time also as a lawyer, specialized lawyer, sometimes with specific fields, conduct systematic deep search, like for keywords or whatever information. But do you have any suggestions for non-patent lawyer backgrounds persons to do basic searching? Like at USPTO, we actually sometimes search some patents in there.
Yeah, I mean,
And other data sort of Google patents, now ChatGPT, right? So any resources that you can think of that can be beneficial for, for
Yeah.
scientists to use.
I use Google Patents all the time. the Google Patents actually more sophisticated than you think. You just have to get past the main search query. And after you get past the main search query, the interface changes. You can have more
Logics.
define more logics into the search string. The problem with searching on your own is that you don't know, you need to understand how to like, you need to understand, if the claims were this easy, then it would, sure, go look at them on your own, but unfortunately the claims look like this. Or the claims look like, the claims look like this. So you need to understand what the difference is between an issued patent and a pending patent. Then you need to understand, what does this mean, right? And another thing is, in an effort to get your own patent, you're obligated to show to the patent office every single thing that is that you know of that's material to what you're putting in your patent application. Secondly, more importantly, is that once you're exposed to this, let's say you're exposed to this, you didn't understand what those words meant, and you kind of never really thought about it again. But then it turns out that the company does infringe this patent, and you never told me about it because you didn't think it was that important. When you get sued for patent infringement, your royalties that you owe can get multiplied by 3 because you knew about, they can prove that you knew about it. So I don't tell my clients, hey, don't search for patents on your own. You're entitled to do it, and I'll tell you how to do it properly. But you just need to be careful. And if you're gonna do it and you see something interesting, like err on the side of like telling me about it.
Yeah, we're not talking about